Rule 135. Powers and duties of courts and judicial officers. Section 1. Courts always open, justice to be promptly and impartially administered. Courts of justice shall always be open, except on legal holidays, for the filing of any pleading, motion, or other papers, for the trial of cases, hearing of motions, and for the issuance of orders or rendition of judgments. Justice shall be impartially administered without unnecessary delay. Sector 2. Publicity of proceedings and records. The sitting of every court of justice shall be public, but any court may, in its discretion, exclude the public when the evidence to be adduced is of such nature as to require their exclusion in the interest of morality or decency. The records of every court of justice shall be public records and shall be available for the inspection of any interested person, at all proper business hours, under the supervision of the clerk having custody of such records, unless the court shall, in any special case, have forbidden their publicity, in the interest of morality or decency. Section 3. Process of superior courts enforced throughout the Philippines. Process issued from a superior court in which a case is pending to bring in a defendant, or for the arrest of any accused person, or to execute any order or judgment of the court, may be enforced in any part of the Philippines. Section 4. Process of inferior courts. The process of inferior courts shall be enforceable within the province where the municipality or city lies. It shall not be served outside the boundaries of the province in which they are compromised except with the approval of the judge of first instance of said province, and only in the following cases. When an order for the delivery of personal property lying outside the province is to be complied with. When an attachment of real or personal property lying outside the province is to be made. When the action is against two or more defendants residing in different provinces, and when the place where the case has been brought is that specified in a contract in writing between the parties, or is the place of the execution of such contract as appears therefrom. Writs of execution issued by inferior courts may be enforced in any part of the Philippines without any previous approval of the judge of first instance. Criminal process may be issued by a justice of the peace or other inferior court, to be served outside his province, when the district judge, or in his absence the provincial fiscal, shall certify that in his opinion the interest of justice requires such service. Section 5. Inherent powers of court. Every court shall have power to preserve and enforce order in its immediate presence, to enforce order in proceedings before it, or before a person or persons empowered to conduct a judicial investigation under its authority, to compel obedience to its judgments, orders, and processes, and to the lawful orders of a judge out of court, in a case pending therein, to control, in furtherance of justice, the conduct of its ministerial officers, and of all other persons in any manner connected with a case before it, in every manner appertaining thereto, to compel the attendance of persons to testify in a case pending therein, to administer or cause to be administered oaths in a case pending therein, and in all other cases where it may be necessary in the exercise of its powers, to amend and control its process and orders so as to make them conformable to law and justice, to authorize a copy of a lost or destroyed pleading or other paper to be filed and used instead of the original, and to restore and supply deficiencies in its records and proceedings. Section 6. Means to carry jurisdiction into effect. When by law jurisdiction is conferred on a court or judicial officer, all auxiliary writs, processes, and other means necessary to carry it into effect may be employed by such court or officer, and if the procedure to be followed in the exercise of such jurisdiction is not specifically pointed out by law or by these rules, any suitable process or mode of proceeding may be adopted which appears comfortable to the spirit of the said law or rules. Section 7. Trials and hearings, orders in chambers. All trials upon the merits shall be conducted in open court and so far as convenient in a regular courtroom. All other acts or proceeding may be done or conducted by a judge in chambers, without the attendance of the clerk or other court officials. Section 8. Interlocutory orders out of province. A judge of first instance shall have power to hear and determine, when within the district though without his province, any interlocutory motion or issue after due and reasonable notice to the parties. On the filing of a petition for the writ of habeas corpus or for release upon bail or reduction of bail in any court of first instance, the hearings may be had at any place in the judicial district which the judge shall deem convenient. Section 9. Signing judgments out of province. Whenever a judge appointed or assigned in any province or branch of a court of first instance in a province shall leave the province by transfer or assignment to another court of equal jurisdiction, or by expiration of his temporary assignment, without having decided a case totally heard by him and which was argued or an opportunity given for argument to the parties or their counsel, it shall be lawful for him to prepare and sign his decision in said case anywhere within the Philippines. He shall send the same by registered mail to the clerk of the court where the case was heard or argued to be filed therein as of the date when the same was received by the clerk, in the same manner as if he had been present in court to direct the filing of the judgment. If a case has been heard only in part, the Supreme Court, upon petition of any of the parties to the case and the recommendation of the respective district judge, may also authorize the judge who has partly heard the case, if no other judge had heard the case in part, to continue hearing and to decide said case notwithstanding his transfer or appointment to another court of equal jurisdiction. Rule 136. Court Record and General Duties of Clerk and Stenographers. Section 1. Arms and Great Seal of Court. The arms and Great Seal of the Supreme Court are these. Arms paleways of 2 pieces azure and gules superimposed a balance or center with 2 tablets containing the commandments of God or on either side, a chief argent with 3 mullets or equidistant from each other, in point of honor, a void argent over all the sun ray on and or with 8 major and minor rays. The Great Seal of the Supreme Court shall be circular in form, with the arms as described in the last preceding paragraph and a scroll argent with the following inscriptions, Lex Populusque, and surrounding the whole a garland of laurel leaves, in or around the garland the text Supreme Court, Republic of the Philippines. The arms and the seal of the Court of Appeals shall be the same as that of the Supreme Court with the only difference that in the seal shall bear around the garland and text Court of Appeals, Republic of the Philippines. The arms and the seal of the Court of First Instance shall be the same as that of the Supreme Court with the only difference that in the seal shall bear around the garland and text Court of First Instance, the name of the province, Republic of the Philippines. Section 2. Style of process. Process shall be under the seal of the court from which it issues, be stayed Republic of the Philippines, province or city of to be signed by the clerk and bear date the day it actually issued. Section 3. Clerk's office. The clerk's office, with the clerk or his deputy in attendance, shall be open during business hours on all days except Sundays and legal holidays. The clerk of the Supreme Court and that of the Court of Appeals shall keep office at Manila and all papers authorized or required to be filed therein shall be filed at Manila. Section 4. Issuance by Clerk of Process. The clerk of a superior court shall issue under the seal of the court all ordinary writs and process incident to pending cases, the issuance of which does not involve the exercise of functions appertaining to the court or judge only, and may, under the direction of the court or judge, make out and sign letters of administration, appointments of guardians, trustees, and receivers, and all writs and process issuing from the court. Section 5. Duties of the clerk in the absence or by direction of the judge. In the absence of the judge, the clerk may perform all the duties of the judge in receiving applications, petitions, inventories, reports, and the issuance of all orders and notices that follows as a matter of course under these rules, and may also, when directed so to do by the judge, receive the accounts of executors, administrators, guardians, trustees, and receivers, and all evidence relating to them, or to the settlement of the estates of deceased persons, or to guardianship, trusteeships, or receiverships, and forthwith transmit such reports, accounts, and evidence to the judge, together with his findings in relation to the same, if the judge shall direct him to make findings and include the same in his report. Section 6. Clerk shall receive papers and prepare minutes. The clerk of each superior court shall receive and file all pleadings and other papers properly presented, endorsing on each such paper the time when it was filed, and shall attend all of the sessions of the court, enter its proceedings for each day in a minute book to be kept by him. Section 7. Safekeeping of property. The clerk shall safely keep all records, papers, files, exhibits, and public property committed to his charge, including the library of the court, and the seals and furniture belonging to his office. Section 8. General Docket. The clerk shall keep a general docket, each page of which shall be numbered and prepared for receiving all the entries in a single case, and shall enter therein all cases, numbered consecutively in the order in which they were received, and, under the heading of each case and complete title thereof, the date of each paper filed or issued, of each order or judgment entered, and of each other step taken in the case, so that by reference to a single page the history of the case may be seen. Section 9. Judgment and Entries Book. The clerk shall keep a judgment book containing a copy of each judgment rendered by the court in order of its date, and a book of entries of judgments containing at length in chronological order entries of all final judgments or orders of the court. Section 10. Execution Book. The clerk shall keep an execution book in which he or his deputy shall record at length in chronological order each execution, and the officer's return thereon, by virtue of which real property has been sold. Section 11. Certified copies. The clerk shall prepare, for any person demanding the same, a copy certified under the seal of the court of any paper, record, order, judgment, or entry in his office, proper to be certified, for the fees prescribed by these rules. Section 12. Other books and duties. The clerk shall keep such other books and perform such other duties as the court may direct. Section 13. Index, separating cases. The general docket, judgment book, entries book, and execution book shall each be indexed in alphabetical order in the names of the parties, and each of them. If the court so directs, the clerk shall keep 2 or more of either or all of the books and dockets above mentioned, separating civil from criminal cases, or actions from special proceedings, or otherwise keeping cases separated by classes as the court shall deem best. Section 14. Taking of record from the clerk's office. No record shall be taken from the clerk's office without an order of the court except as otherwise provided by these rules. However, the Solicitor General or any of his assistants, the provincial fiscal or his deputy, the attorneys de officio shall be permitted, proper receipt, to withdraw from the clerk's office the record of any cases in which they are interested. Section 15. Unprinted papers. All unprinted documents presented to the superior courts of the Philippines shall be written on paper of good quality 12 3 inches in length by 8 1/2 inches in width, leaving a margin at the top and the left-hand side not less than 1 inch and 1/2 in width. Papel Catalan, of the first and second classes, legal cap, and typewriting paper of such weight as not to permit the writing of more than 1 original and 2 carbons at one time, will be accepted, provided that such papers is of the required size and of good quality. Documents written with ink shall not be of more than 25 lines to 1 page. Typewritten documents shall be written double-spaced. One side only of the page will be written upon, and the different sheets will be sewn together, firmly, by 5 stitches in the left-hand border in order to facilitate the formation of the expediente, and they must not be doubled. Section 16. Printed papers. All papers required by these rules to be printed shall be printed with blank ink on unglazed paper, with pages 6 inches in width by 9 inches in length, in pamphlet form. The type used shall not be smaller than 12 point. The paper used shall be of sufficient weight to prevent the printing upon one side from being visible upon the other. Section 17. Stenographer. It shall be the duty of the stenographer who has attended a session of a court either in the morning or in the afternoon, to deliver to the clerk of court, immediately at the close of such morning or afternoon session, all the notes he has taken, to be attached to the record of the case, and it shall likewise be the duty of the clerk to demand that the stenographer comply with said duty. The clerk of court shall stamp the date on which such notes are received by him. When such notes are transcribed, the transcript shall be delivered to the clerk, duly initiated on each page thereof, to be attached to the record of the case. Whenever requested by a party, any statement made by a judge of first instance, or by a commissioner, with reference to a case being tried by him, or to any of the parties thereto, or to any witness or attorney, during the hearing of such case, shall be made of record in the stenographic notes. Section 18. Docket and other records of interior courts. Every justice of the peace and municipal judge shall keep a well-bound book labeled docket in which he shall enter for each case. The title of the case including the names of all the parties. The nature of the case, whether civil or criminal, and if the latter, the offence charged. The date of issuing preliminary and intermediate process including orders of arrest and subpoenas, and the date and nature of the return thereon. The date of the appearance or default of the defendant. The date of presenting the plea, answer, or motion to quash, and the nature of the same. The minutes of the trial, including the date thereof and of all adjournments. The names and addresses of all witnesses. The date and nature of the judgment, and, in a civil case, the relief granted. An itemized statement of the cost. The date of any execution issued, and the date and contents of the return thereon. The date of any notice of appeal filed, and the name of the party filing the same. A justice of the peace or municipal judge may keep 2 dockets, one for civil and one for criminal cases. He shall also keep all the pleadings and other papers and exhibits in cases pending in his court, and shall certify copies of his docket entries and other records proper to be certified, for the fees prescribed by these rules. It shall be necessary for the justice of peace or municipal judge to reduce writing the testimony of witnesses, except that of the accused in preliminary investigations. Section 19. Entry on docket of Interior Courts. Each justice of the peace or municipal judge shall, at the beginning and in from of all his entries in his docket, make and subscribe substantially the following entry. A docket of proceedings in cases before Justice of the Peace, or Municipal Judge, of the Municipality, or City, of, in the Province of Republic, of the Philippines. Witness my signature. Disqualification of judicial officers. Rule 137. Sector 1. Disqualification of judges. No judge or judicial officer shall sit in any case in which he, or his wife or child, is pecuniarily interested as heir, legatee, creditor, or otherwise, or in which he is related to either party within the 6th degree of consanguinity or affinity, or to counsel within the 4th degree, computed according to the rules of the civil law, or in which he has been executor, administrator, guardian, trustee, or counsel, or in which he has presided in any inferior court when his ruling or decision is the subject of review, without the written consent of all parties in interest, signed by them and entered upon the record. A judge may, in the exercise of his sound discretion, disqualify himself from sitting in a case, for just or valid reasons other than those mentioned above. Sector 2. Objection that judge disqualified, how made, and effect. If it be claimed that an official is disqualified from sitting as above provided, the party objecting to his competency may, in writing, file with the official his objection, stating the grounds therefor, and the official shall thereupon proceed with the trial, or withdraw therefrom, in accordance with his determination of the question of his disqualification. His decision shall be forthwith made in writing and filed with the other papers in the case, but no appeal or stay shall be allowed from, or by reason of, his decision in favor of his own competency, until after final judgment in the case. Attorney's admission to bar. Rule 138. Section 1. Who may practice law. Any person heretofore duly admitted as a member of the bar, or hereafter admitted as such in accordance with the provisions of this rule, and who is in good and regular standing, is entitled to practice law. Sector 2. Requirements for all applicants for admission to the bar. Every applicant for admission as a member of the bar must be a citizen of the Philippines, at least 21 years of age, of good moral character, and a resident of the Philippines, and must produce before the Supreme Court satisfactory evidence of good moral character, and that no charges against him, involving moral turpitude, have been filed or are pending in any court in the Philippines. Sector 3. Requirements for lawyers who are citizens of the United States of America. Citizens of the United States of America who, before July 4, 1946, were duly licensed members of the Philippine Bar, in active practice in the courts of the Philippines and in good and regular standing as such may, upon satisfactory proof of those facts before the Supreme Court, be allowed to continue such practice after taking the following oath of office. I, having been permitted to continue in the practice of law in the Philippines, Do solemnly swear that I recognize the supreme authority of the Republic of the Philippines, I will support its constitution and obey the laws as well as the legal orders of the duly constituted authorities therein. I will do no falsehood, nor consent to the doing of any in court. I will not wittingly or willingly promote or sue any groundless, false, or unlawful suit, nor give aid nor consent to the same. I will delay no man for money or malice, and will conduct myself as a lawyer according to the best of my knowledge and discretion with all good fidelity as well to the courts as to my clients, and I impose upon myself this voluntary obligation without any mental reservation or purpose of evasion. So help me God. Sector 4. Requirements for applicants from other jurisdictions. Applicants for admission who, being Filipino citizens, are enrolled attorneys in good standing in the Supreme Court of the United States or in any Circuit Court of Appeals or District Court therein, or in the highest court of any state or territory of the United States, and who can show by satisfactory certificates that they have practiced at least 5 years in any of said courts, that such practice began before July 4, 1946, and that they have never been suspended or disbarred, may, in the discretion of the court, be admitted without examination. Sector 5. Additional requirements for other applicants. All applicants for admission other than those referred to in the 2 preceding sections shall, before being admitted to the examination, satisfactorily show that they have regularly studied law for 4 years, and successfully completed all prescribed courses, in a law school or university, officially approved and recognized by the Secretary of Education. The affidavit of the candidate, accompanied by a certificate from the university or school of law, shall be filed as evidence of such facts, and further evidence may be required by the court. No applicant shall be admitted to the bar examinations unless he has satisfactorily completed the following courses in a law school or university duly recognized by the government: civil law, commercial law, remedial law, criminal law, public and private international law, political law, labor and social legislation, medical jurisprudence, taxation and legal ethics. Sector 6. Pre-law. No applicant for admission to the bar examination shall be admitted unless he presents a certificate that he has satisfied the Secretary of Education that, before he began the study of law, he had pursued and satisfactorily completed in an authorized and recognized university or college, requiring for admission thereto the completion of a 4-year high school course, the course of study prescribed therein for a bachelor's degree in arts or sciences with any of the following subjects as major or field of concentration: political science, logic, English, Spanish, history and economics. Sector 7. Time for filing proof of qualifications. All applicants for admission shall file with the Clerk of the Supreme Court the evidence required by Section 2 of this rule at least 15 days before the beginning of the examination. If not embraced within Sections 3 and 4 of this rule, they shall also file within the same period the affidavit and certificate required by Section 5, and if embraced within Sections 3 and 4 they shall exhibit a license evidencing the fact of their admission to practice, satisfactory evidence that the same has not been revoked, and certificates as to their professional standing. Applicants shall also file at the same time their own affidavits as to their age, residence, and citizenship. Sector 8. Notice of applications. Notice of applications for admission shall be published by the Clerk of the Supreme Court in newspapers published in Filipino, English, and Spanish, for at least 10 days before the beginning of the examination. Sector 9. Examination, subjects. Applicants, not otherwise provided for in Sections 3 and 4 of this rule, shall be subjected to examinations in the following subjects: civil law, labor and social legislation, mercantile law, criminal law, political law, constitutional law, public corporations and public officers, international law, private and public, taxation, remedial law, civil procedure, criminal procedure and evidence, legal ethics and practical exercises, in pleading and conveyancing. Sector 10. Bar examination, by questions and answers, and in writing. Persons taking the examination shall not bring papers, books, or notes into the examination rooms. The questions shall be the same for all examines, and a copy thereof, in English or Spanish, shall be given to each examinee. Examines shall answer the questions personally without help from anyone. Upon verified application made by an examinee stating that his penmanship is so poor that it will be difficult to read his answers without much loss of time, the Supreme Court may allow such examinee to use a typewriter in answering the questions. Only noiseless typewriters shall be allowed to be used. The Committee of Bar Examiners shall take such precautions as are necessary to prevent the substitution of papers or commission of other frauds. Examines shall not place their names on the examination papers. No oral examination shall be given. Section 11. Annual Examination. Examinations for admission to the Bar of the Philippines shall take place annually in the city of Manila. They shall be held in 4 days to be designated by the Chairman of the Committee on Bar Examiners. The subjects shall be distributed as follows: First day, Political and International Law, morning, and Labor and Social Legislation, afternoon. Second day, Civil Law, morning, and Taxation, afternoon. Third day, Mercantile Law, morning, and Criminal Law, afternoon. Fourth day, Remedial Law, morning, and Legal Ethics and Practical Exercises, afternoon. Section 12. Committee of Examiners. Examinations shall be conducted by a committee of bar examiners to be appointed by the Supreme Court. This committee shall be composed of a justice of the Supreme Court, who shall act as chairman, and who shall be designated by the court to serve for 1 year, and 8 members of the Bar of the Philippines, who shall hold office for a period of 1 year. The names of the members of this committee shall be published in each volume of the official reports. Section 13. Disciplinary measures. No candidate shall endeavor to influence any member of the committee, and during examination, the candidates shall not communicate with each other, nor shall they give or receive any assistance. The candidate who violates this provision, or any other provision of this rule, shall be barred from the examination, and the same to count as a failure against him, and further disciplinary action, including permanent disqualification, may be taken in the discretion of the court. Section 14. Passing average. In order that a candidate may be deemed to have passed his examinations successfully, he must have obtained a general average of 75% in all subjects, without falling below 50% in any subject. In determining the average, the subjects in the examination shall be given the following relative weights: Civil Law, 15%, Labor and Social Legislation, 10%, Mercantile Law, 15%, Criminal Law, 10%, Political and International Law, 15%, Taxation, 10%, Remedial Law, 20%, Legal Ethics and Practical Exercises, 5%. Section 15. Report of the Committee, filing of examination papers. Not later than February 15 after the examination, or as soon thereafter as may be practicable, the committee shall file its reports on the result of such examination. The examination papers and notes of the committee shall be fixed with the clerk and may there be examined by the parties in interest, after the court has approved the report. Section 16. Failing candidates to take review course. Candidates who have failed the bar examinations for 3 times shall be disqualified from taking another examination unless they show to the satisfaction of the court that they have enrolled in and passed regular 4th-year review classes as well as attended a pre-bar review course in a recognized law school. The professors of the individual review subjects attended by the candidates under this rule shall certify under oath that the candidates have regularly attended classes and passed the subjects under the same conditions as ordinary students and the ratings obtained by them in the particular subject. Section 17. Admission and oath of successful applicants. An applicant who has passed the required examination, or has been otherwise found to be entitled to admission to the bar, shall take and subscribe before the Supreme Court the corresponding oath of office. Section 18. Certificate. The Supreme Court shall thereupon admit the applicant as a member of the bar for all the courts of the Philippines, and shall direct an order to be entered to that effect upon its records, and that a certificate of such record be given to him by the clerk of court, which certificate shall be his authority to practice. Section 19. Attorney's roll. The clerk of the Supreme Court shall keep a roll of all attorneys admitted to practice, which roll shall be signed by the person admitted when he receives his certificate. Section 20. Duties of attorneys. It is the duty of an attorney to maintain allegiance to the Republic of the Philippines and to support the Constitution and obey the laws of the Philippines, to observe and maintain the respect due to the courts of justice and judicial officers, to counsel or maintain such actions or proceedings only as appear to him to be just, and such defenses only as he believes to be honestly debatable under the law, to employ, for the purpose of maintaining the causes confided to him, such means only as are consistent with truth and honor, and never seek to mislead the judge or any judicial officer by an artifice or false statement of fact or law, to maintain inviolate the confidence, and at every peril to himself, to preserve the secrets of his client, and to accept no compensation in connection with his client's business except from him or with his knowledge and approval, to abstain from all offensive personality and to advance no fact prejudicial to the honor or reputation of a party or witness, unless required by the justice of the cause with which he is charged, not to encourage either the commencement or the continuance of an action or proceeding, or delay any man's cause, from any corrupt motive or interest, never to reject, for any consideration personal to himself, the cause of the defenseless or oppressed, in the defense of a person accused of crime, by all fair and honorable means, regardless of his personal opinion as to the guilt of the accused, to present every defense that the law permits, to the end that no person may be deprived of life or liberty, but by due process of law. Sector 21. Authority of attorney to appear. An attorney is presumed to be properly authorized to represent any cause in which he appears, and no written power of attorney is required to authorize him to appear in court for his client, but the presiding judge may, on motion of either party and on reasonable grounds therefore being shown, require any attorney who assumes the right to appear in a case to produce or prove the authority under which he appears, and to disclose, whenever pertinent to any issue, the name of the person who employed him, and may thereupon make such order as justice requires. An attorney willfully appearing in court for a person without being employed, unless by leave of the court, may be punished for contempt as an officer of the court who has misbehaved in his official transactions. Sector 22. Attorney who appears in lower court presumed to represent client on appeal. An attorney who appears to part in a case before a lower court shall be presumed to continue representing his client on appeal, unless he files a formal petition withdrawing his appearance in the appellate court. Sector 23. Authority of attorneys to bind clients. Attorneys have authority to bind their clients in any case by any agreement in relation thereto made in writing, and in taking appeals, and in all matters of ordinary judicial procedure. But they cannot, without special authority, compromise their client's litigation, or receive anything in discharge of a client's claim but the full amount in cash. Section 24. Compensation of attorneys, agreement as to fees. An attorney shall be entitled to have and recover from his client no more than a reasonable compensation for his services, with a view to the importance of the subject matter of the controversy, the extent of the services rendered, and the professional standing of the attorney. No court shall be bound by the opinion of attorneys as expert witnesses as to the proper compensation, but may disregard such testimony and base its conclusion on its own professional knowledge. A written contract for services shall control the amount to be paid therefor unless found by the court to be unconscionable or unreasonable. Section 25. Unlawful retention of clients' funds, contempt. When an attorney unjustly retains in his hands money of his client after it has been demanded, he may be punished for contempt as an officer of the court who has misbehaved in his official transactions, but proceedings under this section shall not be a bar to a criminal prosecution. Section 26. Change of attorneys. An attorney may retire at any time from any action or special proceeding, by the written consent of his client filed in court. He may also retire at any time from an action or special proceeding, without the consent of his client, should the court, on notice to the client and attorney, and on hearing, determine that he ought to be allowed to retire. In case of substitution, the name of the attorney newly employed shall be entered on the docket of the court in place of the former one, and written notice of the change shall be given to the adverse party. A client may at any time dismiss his attorney or substitute another in his place, but if the contract between client and attorney has been reduced to writing and the dismissal of the attorney was without justifiable cause, he shall be entitled to recover from the client the full compensation stipulated in the contract. However, the attorney may, in the discretion of the court, intervene in the case to protect his rights. For the payment of his compensation, the attorney shall have a lien upon all judgments for the payment of money, and executions issued in pursuance of such judgment, rendered in the case wherein his services had been retained by the client. Sector 27. Attorneys removed or suspended by Supreme Court on what grounds? A member of the bar may be removed or suspended from his office as attorney by the Supreme Court for any deceit, malpractice, or other gross misconduct in such office, grossly immoral conduct, or by reason of his conviction of a crime involving moral turpitude, or for any violation of the oath which he is required to take before admission to practice, or for a willful disobedience of any lawful order of a superior court, or for corruptly or willfully appearing as an attorney for a party to a case without authority so to do. The practice of soliciting cases at law for the purpose of gain, either personally or through paid agents or brokers, constitutes malpractice. Sector 28. Suspension of attorney by the Court of Appeals or a court of first instance. The Court of Appeals or a court of first instance may suspend an attorney from practice for any of the causes named in the last preceding section, and after such suspension such attorney shall not practice his profession until further action of the Supreme Court in the premises. Sector 29. Upon suspension by Court of Appeals or court of first instance, further proceedings in Supreme Court. Upon such suspension, the Court of Appeals or the court of first instance shall forthwith transmit to the Supreme Court a certified copy of the order or suspension and a full statement of the facts upon which the same was based. Upon the receipt of such certified copy and statement, the Supreme Court shall make full investigation of the facts involved and make such order revoking or extending the suspension, or removing the attorney from his office as such, as the facts warrant. Sector 30. Attorney to be heard before removal or suspension. No attorney shall be removed or suspended from the practice of his profession, until he has had full opportunity upon reasonable notice to answer the charges against him, to produce witnesses in his own behalf, and to be heard by himself or counsel. But if upon reasonable notice he fails to appear and answer the accusation, the court may proceed to determine the matter ex parte. Seconds 31. Attorneys for destitute litigants. A court may assign an attorney to render professional aid free of charge to any party in a case, if upon investigation it appears that the party is destitute and unable to employ an attorney, and that the services of counsel are necessary to secure the ends of justice and to protect the rights of the party. It shall be the duty of the attorney so assigned to render the required service, unless he is excused therefrom by the court for sufficient cause shown. Seconds 32. Compensation for attorneys de officio. Subject to availability of funds as may be provided by law, the court may, in its discretion, order an attorney employed as counsel de officio to be compensated in such sum as the court may fix in accordance with Section 24 of this rule. Whenever such compensation is allowed, it shall not be less than 30 pesos, p. 30.00, in any case, nor more than the following amounts: 1. 50 pesos, p. 50.00, in light felonies; 2. 100 pesos, p. 100.00, in less grave felonies; 3. 200 pesos, p. 200.00, in grave felonies other than capital offenses; 4. 500 pesos, p. 500.00, in capital offenses. Seconds 33. Standing in court of persons authorized to appear for government. Any official or other person appointed or designated in accordance with law to appear for the government of the Philippines shall have all the rights of a duly authorized member of the bar to appear in any case in which said government has an interest, direct or indirect. Seconds 34. By whom litigation conducted. In the court of a justice of the peace a party may conduct his litigation in person, with the aid of an agent or friend appointed by him for that purpose, or with the aid of an attorney. In any other court, a party may conduct his litigation personally or by aid of an attorney, and his appearance must be either personal or by a duly authorized member of the bar. Seconds 35. Certain attorneys not to practice. No judge or other official or employee of the superior courts or of the office of the Solicitor General, shall engage in private practice as a member of the bar or give professional advice to clients. Seconds 36. Amicus curiae. The court may, in special cases, and upon proper application, permit the appearance, as amici curiae, of those lawyers who in its opinion can help in the disposition of the matter before it, or it may, on its own initiative, invite prominent attorneys to appear as amici curiae in such special cases. Seconds 37. Attorney's liens. An attorney shall have a lien upon the funds, documents, and papers of his client which have lawfully come into his possession, and may retain the same until his lawful fees and disbursements have been paid, and may apply such funds to the satisfaction thereof. He shall also have a lien to the same extent upon all judgments for the payment of money, and executions issued in pursuance of such judgments, which he has secured in a litigation of his client, from and after the time when he shall have caused a statement of his claim of such lien to be entered upon the records of the court rendering such judgment, or issuing such execution, and shall have caused written notice thereof to be delivered to his client and to the adverse party, and he shall have the same right and power over such judgments and executions as his client would have to enforce his lien and secure the payment of his just fees and disbursements. Law Student Practice Rule. Rule 138A. Section 1. Conditions for student practice. A law student who has successfully completed third year of the regular 4-year prescribed law curriculum and is enrolled in a recognized law school's clinical legal education program approved by the Supreme Court, may appear without compensation in any civil, criminal, or administrative case before any trial court, tribunal, board or officer, to represent indigent clients accepted by the legal clinic of the law school. Section 2. Appearance. The appearance of the law student authorized by this rule, shall be under the direct supervision and control of a member of the Integrated Bar of the Philippines duly accredited by the law school. Any and all pleadings, motions, briefs, memoranda, or other papers to be filed, must be signed by the supervising attorney for and in behalf of the legal clinic. Section 3. Privileged communications. The rules safeguarding privileged communications between attorney and client shall apply to similar communications made to or received by the law student, acting for the legal clinic. Section 4. Standards of conduct and supervision. The law student shall comply with the standards of professional conduct governing members of the bar. Failure of an attorney to provide adequate supervision of student practice may be a ground for disciplinary action. SC Circular No. 19, Prom. December 19, 1986. The Integrated Bar of the Philippines. Rule 139A. Inserted by Republic Act No. 6397, which took effect on January 16, 1973. Section 1. Organization. There is hereby organized an official national body to be known as the Integrated Bar of the Philippines, composed of all persons whose names now appear or may hereafter be included in the roll of attorneys of the Supreme Court. Sector 2. Purposes. The fundamental purposes of the Integrated Bar shall be to elevate the standards of the legal profession, improve the administration of justice, and enable the bar to discharge its public responsibility more effectively. Sector 3. Regions. The Philippines is hereby divided into 9 regions of the Integrated Bar, to wit: Northern Luzon, consisting of the provinces of Abra, Batanes, Benguet, Cagayan, Ifugao, Ilocos Norte, Ilocos Sur, Isabela, Calanga Apayao, La Union, Mountain Province, Nueva Vizcaya, and Quirino. Central Luzon, consisting of the provinces of Batan, Bulacan, Nueva Ecija, Pampanga, Pangasinan, Tarlac, and Zambales. Greater Manila, consisting of the city of Manila and Quezon City. Southern Luzon, consisting of the provinces of Batangas, Cavite Laguna, Marinduque, Occidental Mindoro, Oriental Mindoro, Quezon, and Rizal. Bicolandia, consisting of the provinces of Albay, Camarines Norte, Camarines Sur, Catanduanes, Masbate, and Sorsogon. Eastern Visayas, consisting of the provinces of Bohol, Cebu, Eastern Samar, Leyte, Northern Samar, Samar, and Southern Leyte. B. Proceedings in the Supreme Court. Sector 13. Supreme Court Investigators. In proceedings initiated motu proprio by the Supreme Court in other proceedings when the interest of justice so requires, the Supreme Court may refer the case for investigation to the Solicitor General or to any officer of the Supreme Court or judge of a lower court, in which case, the investigation shall proceed in the same manner provided in sections 6 to 11 hereof, save that the review report of the investigation shall be conducted directly by the Supreme Court. Sector 14. Report of the Solicitor General or other court-designated investigator. Based upon the evidence adduced at the investigation, the Solicitor General or other investigator designated by the Supreme Court shall submit to the Supreme Court a resolution containing his findings of fact and recommendations together the record and all the evidence presented in the investigation for the final action of the Supreme Court. See Common Provisions. Sector 15. Suspension of attorneys by Supreme Court. After receipt of respondent's answer or lapse of the period therefore, the Supreme Court, motu proprio, or at the instance of the IBP Board of Governors upon the recommendation of the investigator, may suspend an attorney from the practice of his profession for any of the causes specified in Rule 138, Section 27, during the pendency of the investigation until such suspension is lifted by the Supreme Court. Sector 16. Suspension of attorney by the Court of Appeals or Regional Trial Court. The Court of Appeals or Regional Trial Court may suspend an attorney from practice for any of the causes named in Rule 138, Section 27, until further action of the Supreme Court in the case. Rule 144 Effectiveness. These rules shall take effect on January 1, 1964. They shall govern all cases brought after they take effect, and also all further proceedings in cases then pending, except to the extent that in the opinion of the Court, their application would not be feasible or would work injustice, in which even the former procedure shall apply. The 2019 proposed amendments to the 1997 Rules of Civil Procedure shall govern all cases filed after their effectivity on May 1, 2020, and also all pending proceedings, except to the extent that in the opinion of the Court, their application would not be feasible or would work injustice, in which case the procedure under which the cases were filed shall govern. N. The application and adherence to the said amendments shall be subject to periodic monitoring by the subcommittee, through the Office of the Court Administrator, OCA. For this purpose, all courts covered by the said amendments shall accomplish and submit a periodic report of data in a form to be generated and distributed by the OCA. N. All rules, resolutions, regulations, or circulars of the Supreme Court or parts thereof that are inconsistent with any provision of the said amendments are hereby deemed repealed or modified accordingly. N.